Hi, I'm Christina,
And I'm Nicole.
and we're going to be doing a TED Talk on criminal justice development as a system.
So first we're going to talk about chapters 3 and chapter 4, and then we're going to dive into the articles because they'll explain what we learned in those first two chapters.
First, we're going to dive into chapter 3, which focuses on criminal justice as a system, and basically it focuses mostly on general systems theory by Ludwig von Bertalanffy, and this applies that interdependent units work together and adapt to a changing environment, all towards a common goal. Kraska applied this concept to his human-made family pond because it had all different interworking pieces, such as like rocks, the pump, the waterfall, which kind of like models and mimics the subsystems within the criminal justice system of police, courts, and corrections. This theory can also be applied to the field of criminal justice. So some important terminology for systems theory is homeostasis, which is self-regulation, and the goal is to have an equilibrium between all the subsystems of the criminal justice system, and this can be used by balancing and leaning and supporting on the other subsystems to create sort of a balance between them all. So there's two main strains of the system, one being the open system and the other the closed system. The open system focuses on external changes and stimuli from the environment, so it's more conducive to the environment. And teleological is a term used for open systems that try to reach a specific state or goal. Supersystems are open systems that interact with other systems, and an exchange relationship is only present in open systems, and it's basically the relationship between outside elements in the environment and those within the system. And open systems are best seen through inputs, throughputs, and outputs. And inputs, the next type of system is a closed system, and this lacks that interaction with the environment. Kraska says this leads to entropy in most situations, which is total disorganization or chaos. And a really important term, maybe the most important term within general systems theory, is non-summivity, which is the concept of the whole being larger than the sum of its parts. And an example of this, circling back to Kraska's pond, is that it was one system that was definitely greater than the sum of its parts, with each individual part working together towards the equilibrium through maintaining homeostasis. But everything was changed in an instant by an external stimuli, which actually was a dog ripping through the pool lining. And this shows external change from an outside environment can affect your organization, and you must be able to adapt. Next, we'll transition into thinking about criminal justice as a system. It is definitely larger than the sum of its parts, which is that concept of non-summativity. The subsystems within the larger criminal justice system are police, courts, and corrections, and they all work together towards the common goal of crime reduction. Each of these parts and subsystems strive for homeostasis, leaning on others in support in the event of an external change. There's also the concept of inputs and outputs, which is really important to a system. Some inputs within the criminal justice system are resources, laws, arrestees, victims, the public. Some outputs are punishment, reformed offenders, community service, etc. Systems thinking originated out of mathematics and biology, and support for this thinking began growing during the mid-1900s. By the 1970s, systems theory had established itself in nearly all social and applied sciences. It was also used within the public and private sectors, and as an example, it was used in the Department of Defense. Systems thinking brought along three main changes in the viewing of the criminal justice system. The first being the use of sociological thinking, which is the ability to make sense of complex phenomenon. The criminal justice system is best seen looking at it from the bigger picture or with a macro perspective, because this allows us to think of the 1,000 agencies within the criminal justice system and think of them as one interacting and interdependent agency. The second is that it improves operations of police, courts, and corrections, and the third is that it establishes strong traditions of organizational and managerial concerns. This was the first time it provided insight into organizational structures and functioning within the criminal justice system. Next, we're going to bring it back to the two strains of systems thinking, the first being open system strain. This makes sense of criminal justice by examining it at the macro level. It wants to improve the criminal justice system. It's open to external input, which was that concept of adapting to the outside environment, and it is willing to recognize problems and failures. The next is closed system strain, which does not rely on input from the external environment, and it has instead a really heavy focus on crime control function of agencies. It uses a systems perspective and is extremely defensive to criticism from the environment.
So now moving on to chapter 4, this is a discussion on crime control versus due process. It was a framework developed by Herbert L. Packer. He wrote it in his book, The Limits of the Criminal Sanction. This book was written during a time of the civil rights movement, not a time of political liberalization, so it does mimic some of those themes at the time. It is a theoretical orientation that's pretty straightforward and heuristic. So basically, due process values the freedoms of individual citizens from unjust acts committed by the state, whereas crime control is strictly focused on a repression of crime as its most important function. In his book, Packer believed that criminal sanctions should be used sparingly. The stigma and the loss of liberty due to these criminal sanctions contradicted society's belief of a free and open state. Because of the stigmatization, Packer also believed that status crimes such as drug crimes, prostitution, and gambling should be decriminalized. Criminal sanctions should be reserved for most serious offenses. This raises the question of, is there a balance between crime control and due process? Packer in his book did not suggest that there was or should be a balance between the two. He stated that the reality is that the two are like a pendulum swinging toward due process or crime control depending on the socio-political climate at the time. But Packer did fail to consider all aspects of the criminal justice process. He did leave out corrections and only focused on police and courts. In the 1970s, Griffith, Dunphy, and O'Leary added the family model, which focused on corrections because Packer had left that out. This was what we know today as the 4 R's: rehabilitation, reintegration, restraint, and reform. This also led to the creation of the needs-based justice model, which involves service to victims, offenders, and the community. So a few key takeaways from this chapter is that the CJ system is not balanced. It leans more toward due process, crime control, or a needs-based justice depending on the current political climate. The government also dictates the definition and scope of the problem and thus the system's reaction to it, so i.e. the pendulum swinging back and forth. Also, value choices between two competing systems, the crime control and due process model, are a causal growth mechanism for the criminal justice apparatus.
Now we're going to move on to the Bernard et al. Article, General Systems Theory and Criminal Justice. And previously, general systems theory had been widely used throughout natural, behavioral, and social sciences, and mostly used to understand social and political phenomenons, and it had been most commonly used to study organizational structures. However, it had never been used in criminal justice, and criminal justice wasn't viewed as a system by many researchers due to fragmentation between the subsystems. This article argues that criminal justice is a system, and it explains the theoretical implications of viewing the criminal justice as a system. While much of general systems theory is open to interpretation, one essential component is the interaction of different units working together towards one common cohesive goal. Although for the purpose of this article, criminal justice is viewed as a system, there are some main objections by previous scholars as to why criminal justice shouldn't be a system. The first being a lack of clearly defined goals between the subsystems that make up the criminal justice system, that they have contradictory ideas, and that they are overall fragmented. Hagen's position, and what I think to be the most accurate depiction of criminal justice, is that it kind of falls in the middle of the two extremes. It's not a system or not a system. It's more a loosely coupled system in the sense that each of the subsystems can function independently but are still very related to each other and therefore rely on each other and balance each other out. In this article, Bernard also argued that criminal justice agencies all shared 3 common goals, which is effectiveness, fairness, and efficiency. However, overall, the criminal justice system as a whole has one larger and more main goal, which is crime reduction. After the American Bar Foundation survey, many began supporting criminal justice as a system. However, many people took this definition literally, when the real intention was really just to collectively refer to all the subsystems within the criminal justice system. And each of those subsystems are considered to be overlapping, which is a key concept in all complex organizations. Bernard outlines 9 ways criminal justice acts as a system, the first being that criminal justice has many layers and it uses inputs, processing, and outputs to make it similar to other complex organizations. However, it's extremely important to avoid overloading, and an overloading is when the inputs outweigh the outputs. For example, if police inputs a number of arrests, he must process those arrests and do the arrest paperwork before he goes out and makes more arrests. The second point being criminal justice processes cases, and these cases are offenders, victims, and the public. And successes within the criminal justice system are measured in completed or defective products. Completed products can be offenders becoming non-offenders, or a satisfied victim or public. On the other hand, defective products are considered offenders that become recidivists, and victims and the public which are dissatisfied. The third point is the big problem of when outputs re-enter the system as inputs again. This allows for the criminal justice system to be viewed as undesirable or ineffective. And undesirable are if the products come back as defective, for example, a recidivist, a dissatisfied victim, or a dissatisfied public, because the criminal justice system will have to continue dealing with these people, whether that's through re-putting them through all of the processing, locking them up again, or agents may even have to defend in public actions in a public forum in front of dissatisfied victims or the public. This allows for a self-correcting loop within the criminal justice system, and that can be agencies over time realizing who is responsible for the creation of large numbers of defective products and removing them or firing them and finding more competent workers. However, the real problem is that there's no current standard as to what constitutes too many defective products. And this kind of relies on the big problem surrounding discretion. Discretion not only plays a role in the police officer deciding whether or not the product is completed or defective, but also in deciding whether or not there are too many defective products and if an individual needs to be fired from the organization. Fourth is that there's little agreement on how to achieve the overall goal of criminal justice processing. Each subsystem within the criminal justice system does not work in the same way towards achieving this goal. For example, police might focus on turning offenders into non-offenders without paying much attention to the victims or public. However, the courts could be doing the complete opposite. This section is why many scholars do not believe the criminal justice system to be a system at all, instead because its parts remain fragmented. Fifth is that the lack of standard for determining a completed product allows for all agencies to decide if a product is complete at any stage in the criminal justice process, and it results in many inputs leaving as outputs before reaching the next stage in the process. For example, if a police responds to a domestic violence call, the cop can determine whether or not the offender is a completed product or not based on the likelihood of him or her reoffending. For example, he can arrest him and move him on to the next stage of prosecution, or he can let him go. And that's the determination of whether or not that offender is a completed or defective product. Bernard's sixth topic is a huge one, and it's the concept of backwards pressure. And this is the overall narrowing of a system's processing capacity. So at each stage, it becomes more narrow, and the number of products that can be processed successfully becomes slimmer. For example, backwards pressure explains that the prosecution has less processing capacity than the police, and that judges have even less processing capacity than the prosecution. So each stage has the ability to exert backwards pressure on the stage before them. This concept of backwards pressure often speeds up processing, because it is often quicker and easier to decide that processing is complete than to move the input onto the next phase of the criminal justice system. There is the concept of caseload pressure, which is brought on by the declining processing capabilities at each furthering phase within the criminal justice process. This caseload pressure motivates CJ agents to complete processing as quickly as possible. An example is that it's easier for the police not to arrest the offender than to arrest them and move them onto the next phase of prosecution. There is also an immediate benefit from subduing to backwards pressure, especially for the next stage of the process, because there's one less input being brought in and having to be dealt with. Opposite is the concept of forward pressure, which I see as basically covering the bases of all the employees within the criminal justice system. For example, forward pressure is kind of the concept that makes the criminal justice worker, for example, the police or the prosecution, giving them the desire to move that input further through the case so that they are not blamed for defective processing, and they pass that responsibility off to the member of the next phase. Back to the domestic violence example. If a cop decides that the product is complete, but then he or she reoffends and commits domestic violence again, the cop would be held responsible for making the bad judgment call. So overall, forward pressure reduces blame and is kind of that internal urge to just pass all the products onto the next phase in an attempt to cover your base and therefore not be held accountable for poor judgment calls just because it might be the simpler thing to do at the time. These forwards and backwards pressures create an unavoidable feedback loop of the criminal justice system. And the overall goal is to close cases so that they stay closed, because reopened cases pose a threat of the criminal justice system being labeled as incompetent. However, this sort of feedback loop, in one sense, is that it's not the only option that makes the criminal justice system appear incompetent, because not passing enough cases forward seems like there aren't as many convictions, aren't as many people getting put behind bars, and overall results in a quantitatively lower number of cases that become closed. And thus, the criminal justice system can also appear incompetent in not doing as good of a job. But it kind of raises the question, what's better? Incompetent from making wrong judgment calls, or incompetent from convicting less? And from all of this research, Bernard et al. Found 4 main theoretical implications for the criminal justice being a system. The first being that parts of the criminal justice system are best understood in the context of the whole system. In order to understand all of the forwards and backwards pressures and the feedback loop, you must understand the inputs, the outputs, and goals of each subsystem and agency. The second being that a common goal of the criminal justice system is to close cases so that they stay closed. And this can be explained further through inputs and outputs. An input being an open case, processing to become an output, aka closed case. And a good example of a closed case that stays closed is a plea bargain, because the individual waives his right to reopen that case. The third theoretical implication of CJ as a system, and I think a really important takeaway, is the requirement of competence, which is the requirement of getting competent CJ workers that are capable of making the correct and most educated decision at the time. And Bernard et al. Used a really good analogy, which was actually from Greek mythology, which was when Odysseus was sailing the water between 2 monsters, and he had to stay between them. So the 2 monsters, one represents backwards pressure to move products out of the system to reduce input, and the other represents the forward pressure to send the product onto the next level to cover bases, which is the demand for complete processing. And it's really tough to make those judgment calls sometimes, which is why it's really important and a requirement of workers to be competent. Lastly is the paradox of efficiency. Most systems strive for minimal defectiveness, but zero defectiveness is not a goal of most complex organizations. However, zero defectiveness is the goal of the criminal justice system. And this resorts back to the main concept of closing cases and keeping them closed, which I think is one of the most important takeaways from Burnett et al.'s article.
Moving on to the next article, Samuel Walker describes the American Bar Foundation survey and how that led to the contemporary criminal justice paradigm. The ABF survey ran between 1953 and 1969. It was originally suggested by Supreme Court Justice Robert H. Jackson. This was to address the crisis of the breakdown, delay, and ineffectiveness of the American law enforcement system. Specifically, this survey focused on failure to report crimes, police discretion, and prosecutors' discretion. Frank Remington was the director of this survey. So moving on to the design of this study, it was all based on the assumption that the most important aspects of administration of the criminal justice system are unknown. This whole study came about based on the rejection of the progressive era paradigm. The progressive era paradigm was based on crime commission studies from 30 years previously, which meant these were studies from like the 1900s. Their methodology relied on reformist ideology. It only used available official data. There was no direct observations of CJ agencies. They found that few arrests resulted in prosecution, trial, conviction, or imprisonment, which was considered a failure of the system. This resulted in failure of the system. The survey was also conducted in a formalized legalistic manner, which lacked discretion. They didn't really consider anything about discretion, and it was also administered impersonally. The original plan for the study was to study the organization, administration, and operation of police, prosecution, and defense, courts, and probation, sentence, and parole. However, the original plan was abandoned and changed pretty much midway through. The original study was supposed to be an exploratory ethnographic study, but that was rejected due to lack of predetermined methods and procedures. The original topical outline was a set of questions that were going to be asked for each agency, but it failed to include anything about actual police work and discretion. Remington and Olin, which were the head investigators for this study, took the original outline and just changed the whole thing and made it their own research design. After a shift in focus on their research, Remington and Olin found an overwhelming pervasiveness of discretionary decision-making throughout the criminal justice system, but they also found lawlessness, racism, and causal unprofessional conduct. Remington and Olin's new interpretation of the data brought along the modern CJ paradigm, which states that the problems in administration arising from the substantive criminal law, the pervasiveness of discretion, the extent to which illegal behavior was not simply a matter of bad people, the fact that various criminal justice agencies were interrelated in such a way that they constituted as a criminal justice system. Unfortunately, the complete findings were not published right away due to rapidly changing political environment, and the results had a greater impact on some aspects of the system as compared to others. This survey resulted in 5 key findings. Although some of them seem a little straightforward, they were really advanced for their time. First, the criminal justice process is extremely complex. Second, the role of police is extremely complex. Third, the administration of justice is pervaded by discretion. 4, the decision-making is unstructured by legal norms and formal controls. And 5, various justice agencies make up a criminal justice system in which the actions of one agency affect the actions of another agency. Going back to the first key finding, complexity of the CJ processes sounds really kind of crazy and really general. However, they really just meant that the CJ process was not strictly devoted to law enforcement. They actually were realizing that they had to handle more than just law enforcement. They had to handle social problems and overcriminalization. The most important finding from all of this was the pervasiveness of discretion and the absence of legal and formal controls. Previous researchers failed to consider discretion in any form of study. The results of this study and the development of a new paradigm led to the bail sentencing reform, the shift between crime control and due process, and even criminal justice education. Before this new paradigm, programs like this wouldn't exist. After the new paradigm, criminal justice programs became so popular in schools because they realized that there was more to it than just strictly law enforcement.
Well, that's all we have for today. Thanks for being such a great audience.
I hope you learned a little bit more on criminal justice development as a system.